Advocate Anila Jayaprakash. Welcome to Legal Desk. I am talking about DNA. DNA evidence is one of the strongest forms of scientific evidence used in criminal investigations and court of law. DNA is a person's genetic fingerprint. Except for identical twins, every individual has a unique DNA profile. Because of this uniqueness, DNA evidence can accurately identify a person or completely exclude an innocent person from suspicion. Do you know what is DNA evidence? DNA evidence means using a person's DNA to find out the truth in a legal case. It is found in almost every cell of the human body and carries information that makes each person unique. Except for identical twins, no two people in the world have the same DNA. Because of this uniqueness, DNA works like a biological fingerprint. This is why DNA evidence is considered very strong in criminal and civil cases. Where does DNA comes from? DNA can be found in many biological materials such as blood, saliva, hair, sweat, semen, skin cells, nails, bones and teeth. During daily activities, people unknowingly leave these materials behind. When a crime happens, these traces may remain at the crime scene, on the victim or on object used during the crime. Even a very small amount of biological material is enough for DNA testing if it is properly collected and preserved. How is DNA evidence collected? DNA evidence is collected from the crime scene by trained officers. Samples are carefully taken using gloves and clean tools. Each sample is packed, sealed and labeled properly to avoid mixing or contamination. After collection, the samples are sent to a forensic laboratory. There, experts extract DNA and prepare a DNA profile. This profile is then compared with the DNA of a suspect, victim or relatives. How does DNA evidence help? DNA evidence helps in two important ways. First, it can connect a person to a crime scene. Second, it can prove that a person is innocent. If the DNA from the crime scene matches the DNA of a person, it shows that the person's DNA was present. If it does not match, the person can be completely ruled out. Because of this, DNA evidence has helped to solve many cases and has helped to free innocent people who were wrongly accused. Does DNA evidence always prove guilt? No, DNA evidence does not automatically prove guilt of the accused. It only shows that DNA was present at a place or on an object. It does not explain how and when it got there. For example, DNA may be present because of lawful contact, previous visit, or indirect transfer through another person. This is called secondary transfer. Therefore, court always examine DNA evidence along with other facts, witness statements, and circumstances. What is chain of custody? Chain of custody means the complete record of handling DNA evidence from the moment it is collected until it is presented before the court. Every person who handles the sample must be recorded. If there is any break or doubt in the process, the reliability of DNA evidence can be questioned. Importance of DNA evidence in law. DNA evidence widely used in murder case, rape and sexual offences, paternity and maternity disputes, child swapping cases, missing person cases, identification of dead bodies, etc. Court treat DNA as a strong scientific evidence but not as absolute proof. DNA evidence has some limitations. Sample can be contaminated. Improper collection or storage can affect results. Laboratory errors can occur. DNA presence does not explain consent or intention. Because of these limitations, DNA evidence is usually considered supporting or corroborative evidence. DNA evidence is a powerful scientific tool that helps court to find out the truth. It can identify offenders and protect innocent people. However, its value depends on proper collection, careful testing, and fair legal interpretation. DNA may speak science, but the law decides its meaning. DNA tells science story, but the court decides the final truth. Today I am winding up this video. If you like my video, please like, share and subscribe. See you tomorrow. Bye. Thank you.